Hello, boys and girls, and welcome to the Fearless Floyd Show. I am your host, Fearless Floyd, as always. And the show is on YouTube, Telegram, Rumble, BitChute. Miss anything? Rumble, BitChute, YouTube, Telegram. You can only donate. Fearless Floyd Show, Cash App, Venmo, PayPal. Fearless Floyd Show, yahoo.com, and the Fearless Floyd Show.com, which is up and running. We have a class starting on the 22nd of October, 2022, on a Saturday from 5 to 7. It's a class on trusts. Come check it out. Go to my website and hook up with that. Like, subscribe, share, notification, leave a comment below. I believe I've covered everything, all the administrative stuff I need to take care of. And this video is going to be about, as you've probably clicked on it by now and know that this is an indictment on Trump. And this is my take, something that I wrote in 2019, and I'll show you all that. I know y'all don't think this is a big deal, but it's kind of a politically, it's a big deal down the road. So we'll see how it all turns out. So anyway, let me jump right into the minutia of this video. And I'll leave you guys hanging. I'll get this done as quickly as possible. So, all right, share that. All right, so here's October 18th, 2022. All right, and I want you to look at this date, October 18th. It's that's a staggering fraud. New York Attorney General Letitia James sues Donald Trump, kids, and company. And that's from September 21st, 2022. That's today's date. That's when it was actually published, last month. And this goes into the New York Attorney General Letitia James on Wednesday filed a $250 million lawsuit against former President Donald Trump, his kids, Eric, Ivanka, Donald Trump Jr., and the Trump Organization, allegedly, quote, staggering, unquote, fraud in the family real estate business. The 220-page civil suit, which was filed in Manhattan Supreme Court, accuses the former president and his Trump Organization of fraudulently inflating the value of his prized assets, including his homes and golf courses, to allegedly obtain federal loans and tax benefits. So that's pretty much the gist of that. And this just seems like a rehash of his pre-presidential allegations. However, I took a different tact. I looked at it at a different angle and still came up with the same results, because once you become entrenched in operating in a specific manner, it's difficult to get out of that trench when you really don't know that there's a different way. It may or may not be lawful or legal. So yeah. Anyway, 220-page civil suit. That's quite the indictment. That's a that's a statement. So, like I said, I took a different tact. Let me dive in, and I can share with you guys. And this is more or less how a real indictment would be drafted. That's why I tried to stay in harmony with the basis fundamental construction of a indictment. So, all right, here it is. This is in my Word file, Trump indictment, and you can see this is October 8th, 2019. Well, that's like 3 years ago. All right. The indictment of Donald J. Trump. Here is a very simplistic diagram of very few of the federal crimes Trump has clearly and unequivocally violated that proves beyond a reasonable doubt that Trump and company are a continuing criminal organization that has now encroached upon our democracy from the bowels of the New York Mafia. Be there. Title 18, United States Code, Section 1961, with a little footnote 1 right there, which is down here on this page in the footnotes, which tells you what this footnote is. It's the state of it designates that the state of New York has adopted Title 18, Sections 1961 through 1968, with more specific criminal acts, but encompasses those of the Federal RICO Act. Okay, so right here, you're going to see a number 7. So that would be footnote 7 right here. All right. Yes, I wrote this. There's footnotes 3 through 6. Absolutely, I wrote that. As used in this chapter. And these are links. You can click on that. It's going to give you, see, it'll take you to Cornell Law, give you the definition of what racketeering activity means. Yes, this is a very well put together document. I believe it took me 2 days to totally polish it up. And you can see there's still a couple of little errors, but nothing major. Anyway, nothing structural in the Constitution. As used in this chapter, racketeering activity means any act which is indictable under any of the following provisions of Title 18 United States Code. Section 1341, relating to mail fraud. There are 2 elements in mail fraud: having devised or intending to devise a scheme to defraud or perform specified fraudulent acts, and use the mail for purposes of executing or attempting to execute the scheme or specified fraudulent acts. For 1343, relating to wire fraud, whoever having devised or intending to devise any scheme or artifice to defraud by means of false or fraudulent pretenses, representations, or promises transmits or causes to be transmitted by means of wire, radio, or television communication in interstate or foreign commerce, any writing, signs, signals, pictures, or sounds for the purpose of executing such scheme or artifice shall be fined under this title or imprisoned not more than 5 years, or both. 1344, relating to financial institution fraud. Whoever knowingly executes or attempts to execute a scheme or artifice to defraud a financial institution or to obtain any of the monies, funds, credits, assets, securities, or other properties owned by or under the custody and control of a financial institution by means of false fraudulent pretenses, representations, or promises shall be fined not more than 1 million or imprisoned not more than 30 years, or both. 1503, relating to obstruction of justice. Okay, let me get back over to these footnotes. I actually jumped ahead and I should have read these. Okay, because back up here to, let's just go to 1. Okay, Title 18 United States Code, I read what that says. That's, you know, New York has adopted the Federal RICO Act word for word, and then actually included some other penal statutes that incorporate into the RICO Act criminal offenses. Okay, so number 2, relating to mail fraud and using the United States Postal Service mail unconstitutional U.S. Census Bureau questionnaire. Okay, and here's the link to that from the Wall Street Journal, which is a conservative leaning publication, and that's why I chose the Wall Street Journal. I know, yeah, I'm good like that. And here's 3456, which is using broadcast airwaves to support unconstitutional U.S. Census Bureau questionnaire. Sondland, Volker, Taylor using the WhatsApp and Crispin app communicate the scheme. That's from Politico. Trump's repeated statements of non-cooperation of congressional subpoenas. That's CNBC. Sondland calling Trump by phone between 4 or 5 hour gap in WhatsApp text of Sondland and Taylor back at the same place. And Michael Cohen's testimony that Trump inflated wealth to $4 billion to purchase Buffalo Bills, and that's out of the Wall Street Journal as well. Now, in an indictment, okay, these don't need to be stated. I put them in here just to support and uphold of exactly, what this violation is or this criminal offense and where it was applied by Trump and company. So you get a correlation to what you're trying to comprehend with this. Sorry about that. Lost my train of thought. Going through now. Anyway, I'll get to it. I remember. Anyway, 1344 relating to financial institution fraud. I just went through that one. 1503 relating to obstruction of justice. Whoever corruptly or by threats or force or by any threatening letter or communication endeavors to influence, intimidate, or impede the due administration of justice shall be punished as provided in subsection B. The punishment for an offense under this section is, in any other case, imprisonment not more than 10 years, a fine under this title or both. That's 8, 9, and 10 of the footnotes. So I will scroll down here and we will look. Trump's repeated statements of non-cooperation of congressional subpoenas. CNBC link. 9 is Hope Hicks dodges questions on the order of the White House. That's a Politico link. Number 10, Trump sends letter to Congress of notice not to cooperate with impeachment proceedings. And that's out of USA Today. And then 13 is again a repeat of footnotes 1 through 10, which would be right there. Okay, relating to tampering with the witness, victim, or informant. But anyway, back up here, relating to obstruction of justice, whoever corruptly or by threat, by force. I already read that one. 1510, relating to obstruction of criminal investigations. Whoever willfully endeavors by means of bribery to obstruct, delay, or prevent communication of information relating to a violation of any criminal statute of the United States by any person to a criminal investigator shall be fined under this title or imprisoned not more than 5 years or both. As used in this section, the term criminal investigator means any individual duly authorized by a department, agency, or armed force of the United States to conduct or engage in investigations of or prosecutions for violations of the criminal laws of the United States. 1512, relating to tampering with a witness, victim, or informant, or an informant. Whoever knowingly uses intimidation, threatens, or corruptly persuades another person or attempts to do so or engages in misleading conduct toward another person with the intent to influence, delay, or prevent the testimony of any person in an official proceeding, cause or induce any person to withhold testimony or withhold a record, document, or other object from an official proceeding, alter, destroy, mutilate, or conceal an object with intent to impair the object's integrity or availability for the use in an official proceeding, evade legal process summoning that person to appear as a witness or to produce a record, document, or other object in an official proceeding, or be absent from an official proceeding to which such person has been summoned by legal process, or hinder, delay, or prevent the communication to a law enforcement officer or judge of the United States of information relating to the commission or possible commission of a federal offense or a violation, conditions of probation, supervised release, parole, or release pending judicial proceedings, shall be fined under this title or imprisoned not more than 20 years or both. I hope I'm hearing this, and I don't think I am. Oh, nope. Right? Okay. My bad. So here it is, the indictment. Let me where well, oh, here we go. back to this. Oh, here we go. Version history. Just so you, right there. There it is. There's my October 8th. I'm gonna have to speed through this to catch up where I was. So anyway, here it is. Indictment of Donald H. Trump. Okay. Thousand New York Mafia. Well, there's 1341, 1343, 44, 1503, 1510, 1512. So I believe I just read. Okay. All right. 1512. Relating to tampering with a witness, victim, or an informant. Yes. I'll call you right back. Bye. Number 11, right here. So we'll go down here. Oh yeah, we're down here. Okay. Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for the use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding, or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. Whoever intentionally harasses another person or thereby hinders, delays, prevents, or dissuades any person from attending or testifying in an official proceeding, reporting to a law enforcement officer or judge of the United States to commission or possible commission of a federal offense or a violation of conditions of probation or supervised release, parole, or release pending judicial proceedings, arresting or seeking the arrest of another person in connection with a federal offense or causing a criminal prosecution or a parole or probation revocation proceeding be sought or instituted or assisting in such prosecution or proceeding, or attempts to do so shall be fined under this title or imprisoned not more than 3 years or both. In a prosecution for an offense under this section, it is an affirmative defense as to which the defendant has the burden of proof by preponderance of the evidence that the conduct consisted solely of lawful conduct and that the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully. For the purpose of this section, an official proceeding need not be pending or about to be instituted at the time of the offense, and the testimony or the record, document, or other object need not be admissible in evidence or free of claim of privilege. In a prosecution for an offense under this section, no state of mind need to be proved with respect to the circumstance that the official proceeding before a judge, court, magistrate, judge, grand jury, or government agency is before a judge or a court of the United States magistrate judge, bankruptcy judge, federal grand jury, or a federal government agency, or that the judge is a judge of the United States, or that the law enforcement officer, an officer of the or employee of the federal government, or a person authorized to act for or on behalf of the federal government, or serving the federal government as an advisor or consultant. There is an extraterritorial federal jurisdiction over an offense under this section. A prosecution under this section or section 1503 may be brought in the district in which the official proceeding, whether or not pending or about to be instituted, was intended to be effected, or in the district in which the conduct constituting the alleged offense occurred. If the offense under this section occurs in connection with the trial of a criminal case, the maximum term of imprisonment which may be imposed for the offense shall be the higher of that otherwise provided by law, or the maximum term that could have been imposed for any offense charged in such case. Whoever conspires to commit any offense under this section shall be subject to the same penalties as those prescribed for the offense of the commission, which was the object of the conspiracy. 1513, relating to retaliating against a witness, a victim, or an informant. Footnote 12, which should take you prompt, equates incorrectly that whistleblower is a traitor and a spy and should be executed as such. And that's out of Reuters, which you should know who owns Reuters. 1513, relating to retaliating against a witness, victim, or an informant. Whoever kills or attempts to kill another person with an intent to retaliate against any person for the attendance of a witness or a party at an official proceeding, or any testimony given, or any record, document, or other object produced by a witness in an official proceeding, or providing to a law enforcement officer any information relating to the commission or possible commission of a federal offense or a violation of conditions of probation, supervised release, parole, or release pending judicial proceedings shall be punished as provided in paragraph 2. The punishment for an offense under this subsection is, in the case of a killing, the punishment provided in sections 1111 and 1112, and in the case of an attempt, imprisonment for not more than 30 years. Whoever knowingly engages in any conduct and thereby causes bodily injury to another person or damages the tangible property of another person or threatens to do so with the intent to retaliate against any person for the attendance of a witness or party at an official proceeding, or any testimony given, or any record, document, or other object produced by a witness in an official proceeding, or any information relating to the commission or possible commission of a federal offense or a violation of conditions of probation, supervised release, parole, or release pending judicial proceedings given by a person to a law enforcement officer, or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. If the retaliation occurred because of attendance at or testimony in a criminal case, the maximum term of imprisonment which may be imposed for the offense under this section shall be the higher of that otherwise provided by law, or the maximum term that could have been imposed for any offense charged in such case. There is extraterritorial federal jurisdiction over an offense under this section. Whoever knowingly, with the intent to retaliate, takes any action harmful to any person, including interference with the lawful employment or livelihood of any person, for providing to a law enforcement officer any truthful information relating to the commission or possible commission of any federal offense, shall be fined under this title or imprisoned not more than 10 years or both. Whoever conspires to commit any offense under this section shall be subject to the same penalties as those prescribed for the offense of the commission for which the object of the conspiracy. The prosecution under this section may be brought in a district in which the official proceeding, whether pending, about to be instituted, or completed, was intended to be effected, or in the conduct, or in which the conduct constituting the alleged offense occurred. Definitions. State means any state of the United States, District of Columbia, the Commonwealth of Puerto Rico, any territory or possession of the United States, any political subdivision, or any department, agency, or instrumentality thereof. Person includes any individual or entity capable of holding a legal or beneficial interest in property. Enterprise includes any individual, partnership, corporation, association, or other legal entity, or any union or group of individuals associated in fact, although not a legal entity. Pattern of racketeering activity requires at least 2 acts of racketeering activity, one of which occurred after the effective date of this chapter, and the last of which occurred within 10 years, excluding any period of imprisonment after the commission of a prior act of racketeering activity. That's that tolling enhancement. Racketeering investigator means any attorney or investigator so designated by the Attorney General and charged with the duty of enforcing or carrying into effect this chapter. Racketeering investigation means any inquiry conducted by any person, conducted by any racketeering investigator for the purpose of ascertaining whether any person has been involved in any violation of this chapter or of any final order, judgment, or decree of any court of the United States duly entered in any case or proceeding arising under this chapter. Documentary material includes any book, paper, document, record, recording, or other material. And the Attorney General includes the Attorney General of the United States, the Deputy Attorney General of the United States, the Associate Attorney General of the United States, and any Assistant Attorney General of the United States, or any employee of the Department of Justice, or any employee of any department or agency of the United States so designated by the Attorney General to carry out the powers conferred on the Attorney General by this chapter. Any department or agency so designated may use in investigations authorized by this chapter either the investigative provisions of this chapter or the investigative power of such department or agency otherwise conferred by law. And there you go. And everything's in these footnotes, in these links. So let's just open it up and see where we go. There it is. Trump seeks whistleblower sources mentions treason report. President Donald J. Trump told staff from the U.S. mission to the United Nations on Thursday he wanted to know who provided information to a whistleblower on his phone call with the Ukraine president, likening them to a spy, two newspapers reported. I want to know, this is a quote, allegedly from DJT. I want to know who's the person who gave the whistleblower the information because that's close to a spy, unquote. I'm going to quote again. You know what we used to do with them in the old days when we were smart, right? The spies and treason, we used to handle it a little differently than we do now. There you go. All I do is you put it out there. And you have to kind of understand where, how that evolves, in the whole Trump inner sphere, I'll call it, his little close-knit family that seem to run the show. When you're doing this as a prosecutor and you're putting this together, me having gone through a criminal trial, so I understand the complete process from, getting pulled over by law enforcement all the way to sitting in front of you, that whole process, everything, appeals, post-convictions, actual innocence claims, the whole nine yards, done it all to get to here. All it takes is a presentation to the jury by the adversarial opponents, i.e. the plaintiff and the defendant, or prosecution and defense, whatever labels you want to give them. Keep losing my train of thought today for some reason. Must be a bad day. It's about believability. Which presentation has the most believable witnesses and evidence? That's going to rule the day. So it's not hard when you take, words out of context and present them in enough circumstantial manners and repetitive enough to get believability or get some traction out of it. So just what I allege was, I mean, they have a billion, trust me, they have $1 billion law firm behind them to support that prosecution. So they have way more resources and materials and brain power than I do. But anyway, that's what I put together. That's what I want to show you guys, that it's not hard to draw up an indictment in 220 pages. So there's basically a lot of stories, and how I put that together. My indictment was the condensed version, because instead of telling you the story in the indictment, I just put a link and a footnote. So you go to that footnote and boom, there's the story that supports the indictment. So the indictment's just giving you the fundamental construction of the law that supports the allegations that are in the actual footnotes, prescribed by the different Title 18 section violations, like 341 and 1501, 1503 rather. So anyway, thank you for watching this video, and I hope you liked it, got something out of it. I just wanted to kind of turn you guys onto that I was way ahead of the curve, of course, as always. And something I put together, and I wanted to do this video as soon as that was announced, and of course it got pushed to the back burner. And I was thinking about it today, and I was like, yeah, just go ahead and pop that up and do that, knock that out. So this is my warm-up video for today. So if you liked it, like me, like the channel, like anything, you like my guests, man, you like the grass, it's outside of on the other side of the fence because it's greener, hit that like, subscribe, notification, leave a comment below, share this video, go to my website, fearlessfloydshow.com. I'm on Rumble, BitChute. Go join my Telegram group. I've got a trust class coming up October 22nd, Saturday at 5 o'clock. Go to fearlessfloydshow.com to enroll in that class. There's limited seats left. So I'd like, get a nice, juicy, fat third class in there to mix it up with the first two classes. They seem to be I got some really progressive students in there. So I'm happy for that. And yeah, come on and join us, get in that private trust group that I have set up. And start working these trusts. And with that, thank you. I hope you enjoy your Tuesday. Oh my God, where did all this blood come from? Oh no, scratch my arm. All right, I have to go address that. And with that, I bid you adieu. Address this and change shirts. Thank you, kids. Appreciate you. Have a great day. Bye-bye.